Okay, the next case we'll take up will be R&W Rental versus Warnick. May proceed.
May it please the Court, Kevin Franz on behalf of R&W Rentals, I respectfully reserve 5 minutes for rebuttal.
Okay.
The trial court abused its discretion in granting a mistrial because the one cutoff, isolated line in closing simply did not vitiate the entire trial proceedings. The second argument is that the trial court erred in denying the motion for directed verdict and denying the motion for judgment in accordance with the directed verdict because there was quite simply no evidence of negligence in this case, ultimately, which is what was found by the jury. So the judge...
On the first issue, are you maintaining that the comment was not improper, or is your primary argument that it wasn't prejudicial enough to justify a mistrial?
Essentially both, Your Honor. The ruling was based on golden rule violation. Quite simply, this was not a golden rule violation. That's when you ask a jury to put yourselves in their shoes.
Was it a conscience of the community?
It was not a conscience of the community, and I'll explain why. So a conscience of the community argument extends to all impassioned and prejudicial pleas intended to evoke a sense of community law through common duty and expectation. Generally, where an argument is not otherwise inflammatory or egregious, an isolated statement is only harmful if coupled with an argument for punitive damages. This was a cutoff line. I agree that it was not the best use of words. I can't get around that. It was inartful.
That argument can be improper even if there's no punitive damages involved.
Right, but I don't believe this was a conscious community argument because there was no impassioned plea to the juries to sort of evoke a sense of community law through common duty.
Counsel, sorry.
Could the comment be, reasonably interpreted to mean instead of deciding this case on the evidence, you should consider the effect on homeowners in Volusia County?
I don't believe so because it was a cutoff comment. It was never repeated again. The attorney did not say you as jurors will be affected as homeowners of this community. In fact, the record is, and this is important, the record is silent as to whether or not these jurors were homeowners. That is not in the record. They absolutely could have been
right,
renters.
But did they fill out written questionnaires?
I'm not sure. They probably did, but in the record, and there was nothing during voir dire discussing whether they were homeowners or not.
But the trial judge might know that.
It's possible if they disclose that information, but the key is that the attorney did not know that. And you have to have sort of intent to evoke a passion.
Well, we don't know if the attorney knew that or not, because if you got written questionnaires for jury selection and they're not made part of the record, I mean, we don't know what's in the questionnaires, but I'd assume the attorneys and the judge knew.
But I don't think that I don't think there is anything in the record. Even if there were juror questionnaires, I don't necessarily believe that when you put an address down, you have to say whether you're a homeowner or you're renting that address. I just don't think that's in the record. And I think a great example of why this was not a conscience of community argument is based on the case that both parties cite in their briefs, and that's Norman versus Gloria Farms. So in that case, the plaintiff sued for injuries while hog hunting on defendant's property. The opinion says hog hunting is a popular sport in Okeechobee County. The record in that case did reflect that 4 of the 6 jurors were hog hunters. And the defense counsel capitalized on this. And I'm going to paraphrase basically what the argument was. A verdict for the plaintiffs will bring an immediate halt to hog hunting in Okeechobee County. No rancher in this town would allow hog hunting on their property ever again. You need to decide this as an Okeechobee resident, and your message will be heard by every landowner in Okeechobee County. When you contrast that with a cut-off, isolated statement here, it's clear to see that this was simply not a conscience of the community argument. This was an attempt simply to comment on the evidence. The defendant is a homeowner. This was the very beginning of the closing argument.
The comment was, though, asking the jurors or imploring the jurors that they had the ability to protect homeowners. That's not a comment on the evidence.
I think it was a poor choice of words. I'm not going to beat around the bush, but I don't think that it was the same as an impassioned plea. And, Your Honors, even if this was an improper statement, which, again, my position is it's not, but even if this court and the trial court believed it was improper, it was still an abuse of discretion to grant the mistrial.
Well, why was it an abuse of discretion? It's a very deferential standard. How can we say that no reasonable judge would basically have done what the trial court did here?
Because you have to look at, well, there's a couple reasons. First of all, The mistrial should not be granted unless there's an absolute legal necessity. And in closing arguments, to determine whether something is improper, you can't just look at this single isolated statement. The case law in this court, MacArthur versus State from the 5th DCA, recognizes there's wide latitude in closing arguments, and you have to review the comment in the context not only of the entire closing argument, but you have to view it cumulatively with the entire trial. And in this case, there was a passing comment. The judge says you can't do that. So counsel said, never uttered the words Volusia County, never said homeowners, never said protect anyone again. In fact, there were no further objections whatsoever with regard to the remainder of the closing argument. The theme of the closing argument in this case was not to protect the homeowners. The theme was that we have a professional adjuster who testified he's been in over 200 attics, who said he's responsible to assess his environment, and that he could have easily figured out that this was particle board he was stepping on, but he did not. The closing argument was discussing that and discussing that R&W rental was simply not negligent. There was no blistering attack or call to arms or anything of the sort. In fact, this was such a clean trial that the trial judge even commented on the professionalism of the parties. So this is not a case where you have one attorney capitalizing on something to make an impassioned plea and in the court realizing, oh, they went too far. The court here recognized the professionalism of the attorneys.
But most of the cases in your brief are ones where the trial judge denied the motion for mistrial based upon an improper comment in closing, and this court affirmed, or another appellate court affirmed. Here we have a different situation. The trial judge granted it. And so, the abuse of discretion standard is deferential. So your argument needs to focus not on those cases where we affirmed a denial, but why this was an abuse of discretion. I mean, that it clearly was not prejudicial. And I understand your theme. I mean, I think I agree with you. I read the closing argument. I read the opening statement. I don't see where this was a theme. But the trial judge had the benefit of seeing how the jury reacted to witnesses and things like that. What do we do with that?
I can answer your question. I have cited 3 cases where there was a mistrial granted based on an improper argument, and the appellate courts reversed the case. One case is out of the 5th DCA in Schaefer versus Ward, where the argument was, you all drive, you're on the road, talking to the jurors, of course. You know the importance of brake lights. You weren't negligent or not paying attention. And there was, I'm sort of paraphrasing the argument, but the court granted a new trial based on an improper golden rule violation, and this court reversed and remanded, saying that was an abuse of discretion to do so. That was not a golden rule argument. It did not vitiate the trial. We cited the case Wilbur versus Hightower, where the court granted a motion for mistrial based on the conscience of the community argument. And the argument was to the effect of, you, the jury, need to come back here with a verdict you can be proud of, and my client can come up here and shake your hands and say, you've made sense out of this. Don't let these people go back to their offices and laugh in the hall room and say we put one over them. The trial court granted a mistrial. The appellate court reversed and said that did not vitiate the entire trial. I think a really good example of a case, this was where a mistrial was denied, but I think a really good example that fits into this is from this court, Smith versus State. And the closing argument was, this was obviously a criminal trial, and the prosecutor said, you are the citizens that speak on behalf of your community, and in order to be qualified as a juror to sit in this court, you have to be a resident of the county where this crime occurred and where this crime is being tried. You are the citizens that speak on behalf of your community in rendering a verdict in this case. Now, granted, the trial court denied the motion for mistrial, but this court examined that language to see, okay, what are we dealing with? Is this such to vitiate the entire trial? And this court said no. The reference to the jury speaking for the community did not permeate the closing argument. Rather, it was near the end of the argument and was not repeated after defense objected. This isolated and limited comment would not appear so prejudicial to vitiate the entire trial, and thus a mistrial was not warranted. That is precisely what we have here. It just occurred at the very beginning. It was an isolated comment. It was not even a complete thought. It was cut off. This is actually...
Do you think that a trial court abuses its discretion anytime there's an isolated comment?
No.
And the trial court grants a mistrial?
I do not think so. But I think it has to be, as this court said, taken into account the entire closing argument. So if there is a case where there's an improper argument, and that objection is either sustained or, let's say, it's overruled, and then counsel hammers on that and makes that the theme of their entire closing argument, that may be a circumstance where one isolated comment at the beginning that's cut off, when you consider it in context with the entire trial, vitiates the entire trial. That is absolutely not what occurred here. There was no objections, and on this first issue, we would respectfully request, there's one more point I would make. This could have been cured easily. There was no request for a curative argument. If anything was improper, there could have been a simple curative that said, disregard the comment.
The jury selection in this case, is it correct the judge conducted it all? Or did you all ask questions?
I believe the counsel also asked questions. I can't recall that 100%, but I believe that that did occur. The counsel was asking questions during voir dire.
And I don't recall anything, maybe you can help me, was there anything on being a property owner?
Absolutely, that did not come up at all. So we have no idea whether these jurors were property owners. We would request that the court reverse and remand to reinstate the jury's verdict of a defense verdict. The second argument is quite simply, was it error to deny the directed verdict on negligence? And we rely really on the Dampier versus Morgan Tire case, which is from this district. And essentially, as the court knows, there's two duties of care to invitees. You have a duty to warn, you have a duty to maintain the premises in a reasonably safe condition. In this case, we have an open and obvious danger, which obviates the need for a duty to warn, but not necessarily the duty to maintain the premises. However, the Dampier court talked about an exception, and that is when the condition is so dangerous, the conditions are dangerous but are so open and obvious that an invitee may be reasonably expected to discover them and protect himself. In that case, the landowner is absolved of liability. That quote was then quoted by the first DCA recently in Brookie versus Winn-Dixie stores, which affirmed a summary judgment where a plaintiff tripped over an empty pallet in a store. The property owner complies with both duties of care, where the condition, again, is so open and obvious that the invitee may be reasonably expected to discover them to protect himself. In this case, it is undisputed that a particle board is not designed as an area to walk on in an attic.
But there is a dispute over whether the board that was stepped on was obviously particle board.
And that is what the plaintiff has argued, but I will argue that that is irrelevant, whether he knew or didn't know it was particle board, because it was so obvious, and he admitted it was so obvious, that he could have easily discovered this to protect himself. He testified, it's obvious you don't walk on particle boards. He testified there, he went up the ladder, he turned on the light. He had a flashlight with him. He was asked, you saw the boards in front of you. Were they nailed down? No, they were not nailed down. Could you have easily picked up the board and discovered that it was particle board? Yes, I could have easily done that. He testified he was very familiar with dangers in attics. Why? Because he's a professional who had been
Counsel,
in over
how
200 attics.
does that change the duty analysis, right? So you send a professional up into the attic versus you send a lay person up into the attic to retrieve something. How does that factor into the duty analysis?
It's significant because I have a case, this was not really discussed in the briefs, but I actually thought you might ask this. I have a case that's not in the briefs I'd like to quote for your honor, which says, where the negligent party is a professional, the law imposes a duty to perform the requested services in accordance with the standard of care used by similar professionals in the community under similar circumstances. So it's not some heightened duty, it's just that as a professional who's been in 200 attics, he has a duty of care as any other professional who had been in 200 attics.
But a jury infer, though, that since he has been in so many attics, that maybe it wasn't obvious that this was particle board, even as somebody who had been in hundreds of attics and seen hundreds of boards.
The jury could not infer that because that would be contrary to Mr. Warnick's own testimony, who said, he basically said, I know what particle board is. I know if you look at it from the side, you can tell whether something's particle board. This board was not nailed down. So he was asked if you could discover that. He said, yes, I could have discovered that.
Well, being able to discover it is different from being open and obvious.
Well, and I think that's where you go back to the Dampier case, because it says some conditions are so open and obvious that the invitee may be reasonably expected to discover them and protect themselves. So in this case, he basically admitted at trial that he said he's a professional. He doesn't ask anybody how to do his job. He doesn't need to do that. He could have easily, and he said, I could have easily inspected this,
Well,
essentially.
he could have discovered it goes to comparative negligence. Open and obvious is something different.
I don't think this goes to comparative negligence. And the reason I keep going back to this Dampier case, in that case, somebody was walking on a sidewalk, went into landscaping and tripped over some bushes or roots or something like that. And the issue there did not go to comparative negligence, whether he had just made him, it was his fault for doing that. That was a scenario where the court said, look, this is so open and obvious that this person should have reasonably expected to discover it. The facts of this case fit into that perfectly.
Down to 4.5 minutes.
Judge, I really don't have anything else to argue. I would just respectfully request with regard to this issue that the court reverse and remand for entry of a judgment in accordance with directed verdict, unless this court has any other questions on this issue.
All right, thank you.
Thank you.
Morning, counsel. Good morning. I'd like to start with the passing comment that the counsel talks about. A couple things. One is it wasn't a passing comment. I think it was an instruction that it says that sometimes you get picked and you're in a very special position being a juror. Jurors are the gatekeepers. They're the ones that hear litigation, hear cases, and make decisions that in this case, we would submit to you that you can protect the homeowners of Volusia County. I mean, that's a strong statement.
Well, let me ask you this.
Sure.
I looked at the opening, the jury selection and all. Is there anything or anywhere else in the closing that is similar to that as far as a theme?
No, Your Honor. There was an timely objection made.
All right, so you'd agree it's an isolated comment in that this is the only time defense counsel suggested to the jury something about protecting homeowners?
Protecting homeowners. I can tell you that in the trial, it was relayed that the defendant was a homeowner and that he not only owned that house but owned another house in Volusia County. So I would submit to you that's part of it, that my client was never identified as a Volusia County homeowner in the case at all. But beyond that, the objection was made timely, and the judge didn't overrule the objection, didn't sustain the objection, didn't give an instruction to the jury, just said, I'll take it under advisement. Even after the mistrial, I'll take it under advisement, and the defense continued. So the question is, did the jury think that was their job, was to protect Volusia County homeowners? They never had the opportunity.
There was no request for a curative instruction, though.
Because I wasn't sustained objection. She said, I'll take it under advisement. And my position at the time was that it's too late. I mean, protect the Volusia County homeowners was out there.
Well, the judge did tell the attorney, you know better than that, right?
Right.
She took under advisement the motion for mistrial.
Well, she didn't rule in the objection either. When the objection was, all she said was, Mr. Coleman, I'm not going to allow these kind of comments to the jury. You know better than that. And then there was a motion for a mistrial, and she said, I'll take it under advisement. But she never instructed the jury that the objection was sustained, and that was not appropriate argument, or that the jury shouldn't consider that.
All right. Well, did you ask the judge, or can you make a finding, sustain the objection in the presence of the jury?
No, Your Honor.
Okay.
At the time, I thought that mistrial should have been granted because I thought that the comment itself was enough that the reaction of the jury and the way it was stated was forceful enough that the cat was out of the bag. It was too late. I didn't feel like a curative instruction was going to help.
What about the issue that the objection was based on golden rule instead of conscience of community?
I've looked back at, at the time of the trial, you're kind of looking at it's either a golden rule or conscience of community. It seems to almost be a hybrid, because if you're a homeowner, then you're protecting yourself, putting yourself in the position. And if you're not a homeowner, you certainly know a Volusia County homeowner, or you might have a friend that's a homeowner, or a relative that's a homeowner, or you're going to be a homeowner. So I think it's almost a mixture between the two. Obviously, if they're homeowners, it's the golden rule because they're trying to protect themselves, which are homeowners. If they're not homeowners, then it's more of a conscious of community. But I think it kind of covers both. I don't think we're ever going to find exact languages from case to case because attorneys read those cases and decide, don't use that language because that's absolutely incorrect. So they uses a little bit different, and then the court's got to decide that's still not, that's not.
Well, assuming that we agree with you that this is an improper comment, how is this different from the multitude of cases where a single isolated comment was not enough to justify a mistrial?
Well, those were all, the judge had denied the mistrial. So you would have to, the court would have to see a clear abuse of discretion by the trial court judge. It has to be clear abuse of discretion, not whether they'd come up with something different, but a clear abuse. And in this case, since she granted the mistrial, then the defendant in this case, or the appellant, is going to have to show that the judge made a clear abuse of discretion by granting the mistrial.
Well, the trial court did not explain really the basis, just said, it's called a golden rule and I feel compelled to grant a mistrial. So why is it not abuse of discretion when one, the trial court's basing it on a golden rule, and then also saying that the court feels compelled, maybe on a misunderstanding that golden rule violation is per se reversible? Wouldn't that constitute an abuse of discretion?
It has to be a clear abuse of discretion. I don't think so. I'm trying to kind of grasp what the question is. If I'm understanding you correctly, you're saying if she got if the trial court judge said it's the golden rule violation and she got that part wrong, that it was really conscious of the community.
I think Judge Sasso is asking you, it seems like maybe the trial judge thought that there was no discretion, that mistrial had to be granted. And if so, was the trial court under a misunderstanding of the law?
No, I don't believe she thought it was mandatory to grant the mistrial. I think she took it under her advisement, listened to the rest of the closing and totality of circumstances with the jury, their emotion or expressions or body language, and decided that it did make a difference in the outcome of the case. Now, I'd also look at this where the appellant wants the verdict reinstated, and I'd submit to you that if the trial court reserves a ruling of the mistrial and goes back and says the mistrial is granted, then anything after that motion or order doesn't really count. So the verdict coming back or the actual verdict wouldn't make any difference. And now we're too late to have an curative instruction. You can't go back and tell the judge, okay, bring the jury back, give a curative instruction, because that's how we fix this mistake. It's too late now. Had she
Are there
granted
any cases supporting that position? Because I believe the cases where motions for mistrial are reversed.
Well, the motion of mistrial were at the end of the closing. This one was made, let me give you an example, or a hypothetical. If she would have granted the mistrial right then and there, then there wouldn't have been a verdict to reinstate. So my understanding is that since she reserved the ruling, she went back to where prior to any kind of jury going out or any kind of verdict and said, yeah, the mistrial is granted. So anything after that is a moot point.
But do you have a case to suggest? Because we do have a verdict.
Well,
right,
it's procedural. I wouldn't say I have a case law. I do not have a case. I would say it's more of a procedural argument that if you're reserving a ruling, then anything after the reservation of the ruling you can't have both.
Did the ruling taint the jury's deliberations at all?
No, the ruling didn't come out to
the jury had no idea, right?
The jury was dismissed.
Yeah, but if the plaintiff got a verdict, a favorable verdict, then the judge could have denied the mistrial. You wouldn't go back to that time period.
Yes, it would have. It would have been a denial, and then after the denial, you go forward to the actual verdict, the deliberations of the verdict. So yeah, it would have been. It would have.
Do you have a case anywhere in the country to support
I don't
that?
have a case. Just a procedural argument that it makes logical sense that when judges reserve ruling, even if it's summary judgment where they reserve the ruling, anything that comes after that summary judgment, any kind of litigation that comes about, if the summary judgment's granted, then it's done. The case is over. So I don't think that's. It's the similarity I can.
What about duty, counsel? This isn't a situation where, the neighbor goes up in the attic. This is a professional that was hired, right, to go up into the attic. And from my reading of the record, it seems undisputed that the professional had far more experience in an attic, right, than anybody else.
All right, two things. One is most of the cases that the defense has cited or the appellant has cited were independent contractors. It was already decided by a matter of law that Mr. Warnick was not an independent contractor, so the duty to him was to any business invitee because this was a rental home. So he didn't have a higher standard. The professional part doesn't make any difference. If that's something the defense argued to try, but there is no a lesser duty to Mr. Warnick in this case is to
Why
any
not?
business invitee, because it's any business invitee. It would have been, he would have the same duty to the renters. They're a business invitee.
The
And that
renters
was-
aren't professionals who do this for a living.
Professional goes to comparative. It doesn't go to the duty. And when Mr. Warnick, and this is some of the disputed evidence, yes, he wouldn't work on particle board. He knows it's dangerous. He went up in the attic. What it looked like was what he called walking boards that were across the trusses.
Well, he knew there was a risk and danger, right? Because he tested one of the boards.
And because they had the appearance of being a solid board. They had the veneer on them.
But he tested it.
Right.
So he knew that there was a danger.
Right, and then once he got to the first one, it seemed like it was okay, so the second step is when he went through it. So to say that it's open and obvious, well, it wasn't open and obvious. He would have had to have taken the board out of the attic, bring it down, look at it in the light, determine whether it was the same or not, and then, I'm sorry, if it wasn't open and obvious, he would have to do all these things. It's open and obvious means I can just walk up and look at it without a flashlight, without any lighting, and I can see that obviously this is an issue, I shouldn't step on it. That's not the case we have here. And part of him being, I don't like saying a professional, but having experience being in attics before has shown him that he can walk on these types of boards that homeowners put him in there.
Is the open and obvious analysis different for a professional versus a lay person? I mean, I think what counsel's sort of arguing is, look, I mean, maybe to the next door neighbor who goes in an attic once a decade, this might not have been open and obvious, but to a professional who's up there all the time, isn't it a little bit different sort of analysis?
It only goes to his experience, not the duty part of it. So if his experience of being, if a lay person was in 200 attics, then certainly they can go back and you could use that and say, well, he's been in 200 attics, he has experience. The professional part, he wasn't hired by the business owner, in this case, to go up in the attic, or he wasn't hired at all as an independent contractor, I should say. The insurance company brought him out. So the duty is the same as would be to any business invitee. And that's what, we had one on a summary judgment argument earlier. And I don't think there's even an issue today about what the duty was. The issue today from the appellant is it was overwhelming evidence that he should have seen it, or was open and obvious.
Open and obvious, right.
Right, and that goes against, there's a dispute of facts, and obviously when it's a de novo review here, inferences to the non-moving party, and there's a issue of material fact here, whether it was open and obvious. Our client, or I'm sorry, Mr. Warnick, doesn't say it's open and obvious. I think even the appellant says he had a flashlight. He could use his flashlight. He could have done this. He could have done that. That's not open and obvious. Open and obvious cases aren't what you could have done. It's that anybody can see this, which is not the case. Is there anything else, Your Honors?
No? All right, thank you.
I would just ask to rely on my brief, and then I would ask the court here to affirm the trial court's rulings. Thank you, Your Honors.
Thank you.
With regard to the procedure, Florida law says that if there is a motion for mistrial where the court reserves, the jury comes back and gives a verdict, the judge then discharges the jury and then grants the mistrial. In essence, what that is an order granting a new trial. If that's reversed, then if this court reverses, the proper procedure is to reinstate the jury's verdict because the jury's verdict is final. With regard to counsel saying the plaintiff wouldn't have needed to bring the board outside, bring it down into better lighting to really examine whether it's particle board, that is in contradiction to Mr. Warnick's own testimony. I'm reading from page 235 of the trial transcript. Question, so had you just wanted to stoop down and point your flashlight or touch it or feel it or pick it up a board because it wasn't nailed, you could have looked at the side or the top or bottom of it, couldn't you? Answer, I could have. Question, well, you would agree with me, had you done that, you have enough experience that you could look and say, quote, this is particle board, had you done it. I'm not saying...
Yeah, but that kind of that relies on an inspection, right? I mean, is it open and obvious if an inspection is required?
We're not really talking about a big inspection. I mean, we're talking about a person who's going to walk in an area that he testified he knows is dangerous, and all he needs to do is essentially point his flashlight and pick it up for a second before you're going to walk on boards that He says one of the biggest dangers is falling down through an attic. This isn't something where you need to take this to
Of course, the problem, if you have to use a flashlight, that tells you something about the lighting too, right?
The plaintiff was asked if there was any reason this occurred based on inadequate lighting. He said no. So that lighting is not an issue in this case.
So because he had a flashlight, right?
No. He turned on the light. When he went up the ladder, he turned on the light. Another key.
But you concede in order for him to know, he would have had to inspect the board.
Something is open and obvious if you can just look at the definition, I guess, of open and obvious is when figuring out the danger based on an open and obvious inspection. I mean, you have to do something look at it with your eyes. That this is what would fall into that. As a professional,
But he would have had to do more than just look at it with his eyes, right? In this case.
Well, he wouldn't have had to do too much more, to be honest. All you had to do was lift up the board just to look at it. I don't think because he had to simply lift it up and look at it with his eyes, does that change it into something that is not open and obvious. And again, it's key that, and I'm quoting from page 231 of the transcript, question, so you as the professional need to assess your environment before you proceed into it. Fair statement? Answer, I would say so, yes. So even he admits that he would have to do that. I would like to make
Counsel says that goes to, comparative negligence instead of whether it's open and obvious. Your argument is that this was open and obvious.
And the key is that under the Dampier and the Brookie case, the defendant, the landowner, is absolved of the duty. You don't get into comparative fault. If something is so open and obvious that the person should have reasonably expected to protect themselves, then comparative is out the window. There is the duty on the landowner is absolved. I'd like to make one correction in speaking with trial counsel. The judge conducted the voir dire. Trial counsel did not ask questions, but in the transcript of voir dire, there is never a mention that any of the jurors was a homeowner. If the court doesn't have any other questions.
All right, thank you both.
Thank you.